to Our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hi, and welcome to Our Curious Amalgam, the podcast from the American Bar Association's Antitrust Law section. My name is John Roberti, and today's topic is, where's the future enforcement? The next big enforcement areas in pharmaceutical antitrust. Pharmaceutical antitrust has been a large, important area for antitrust enforcement going back many, many years. Looking back, it was a major focus of the FTC. Really going back to the early 2000s, it became a central focus, I would say, in the late 2000s, as the agency observed new practices happening and brought cases to enjoin them. A big one back then was something that was called pay for delay. And we'll talk a little bit more about what that is today. But what we want to do today is to talk about how innovation, in a lot of different ways, innovative ways of doing products, but also innovative ways of taking advantage, some might argue, of market positions, are influencing enforcement. What are going to be the new areas that are coming? We're going to talk with one of the leading policy experts in this area, somebody who has been doing this, probably 25 years, get his views. And I think what you're going to hear is going to be very interesting. My co-host today is Christina Ma. Hi, Christina.
Hi, John. How are you?
I'm great. So, Christina, what are we doing today?
So, as you say, the pharmaceutical industry has been the subject of immense scrutiny by various regulators, the FTC being one, from exorbitant and sudden increases in drug prices, inequitable access to pharmaceuticals, and relevant for the discussion today, that the business and legal practices that walk a fine line between patent protection and antitrust enforcement. Today, we hope to hear, as you say, from a wonderful guest, Michael Kades, who brings a wealth of experience working in antitrust enforcement in pharmaceuticals, previously having worked as antitrust counsel for Senator Amy Klobuchar, ranking member of the Senate Judiciary Subcommittee on Antitrust, Competition Policy, and Consumer Rights. After a decades-long career at the Federal Trade Commission, Michael is now Director of Markets and Competition Policy at the Washington Center for Equitable Growth. And we're very excited to have him on today.
Great. And Christina, you covered this, but why is this important?
I think we all recognize the importance of affordable medical care, and that includes pharmaceutical products, especially in view of COVID-19. All of these issues have become forefront for everyone.
All right, well, let's bring in our guest, Michael Kades. Welcome to the program.
Thank you so much for having me. I'm very excited to be on and honored that you asked me to come talk with you guys today.
So, Michael, you live these issues day in, day out. We wanted to spend some time today to discuss what you view as sort of the key pharmaceutical antitrust issues coming down the pipeline in enforcement.
Yeah, so I do think that pharmaceutical antitrust enforcement will continue to be a very active area and a priority for the Federal Trade Commission. And I sort of think about this to sort of put it in a larger context is, although recently the tech industry gets all the press coverage and they had the big hearing and lots of people are concerned about the tech industry, and that all makes sense. But in many ways, when we think about how effective antitrust enforcement is in the United States, the pharmaceutical industry is the canary in the coal mine. And the difficulties that the government faces in stopping anti-competitive conduct which is a result of an enfeebled antitrust law, really bodes ill, not just for the cost of prescription drugs going forward, but the state of competition in the United States. And so, I think there's sort of four things worth talking about. One is a place where the government's been very successful, but it took decades. That's the pay-for-delay settlements. Two is one of the most recent enforcement actions by the FTC, which involves a strategy to delay generic competition for a drug called Daraprim, which, if you don't know, that ties in with the farmer bro Martin Shkreli. Three, that the FTC's major enforcement deterrence, disgorgement, is under attack at the Supreme Court. And finally, how this all might play out in the area of biologics, which are more complicated drugs and an increasingly large portion of prescription drug costs in the United States.
So let's start with an area where you've described as one area where the FTC has had some success, which is for pay for delay. Tell us a little bit about what pay for delay is and where present enforcement is on that issue.
Right. So this goes back to the late 1990s. And the thing to understand in the branded pharmaceutical context, in pharma competition context, price competition in pharma really comes almost entirely from between the brand and the generic, right? So when a generic comes on the market, it takes 70 to 90% of the share of the branded product, and that's where its entire share comes from, and it's pricing 20, 30, 40, 50% off the brand price. As more generics enter, the price drops, so that on a fully genericized market, the generics are selling for pennies on the dollar compared to the brand, right? And so what typically determines when that occurs is how strong the brand's patents are. So the generic files for approval, the brand then sues the generic for patent infringement, and then they have litigation. And beginning in the mid-90s, the branded companies and the generics figured out that, so the brand could win and there'd be no competition, or they could lose and the generic would come in and make money, but they'd make a lot less than what the brand loses. So they started entering settlements where the brand would basically say, well, here, we can pay you more than you're expecting to get out of this settlement, and it really represents nothing to our revenue stream. And so why don't you just agree to stay out of the market, either to patent expiration or to the point in time where we're going to move the product to we're going to launch a revised version, what's called product hopping, so we don't really care if there's a generic. And the result is, the brand protects 90% of its profits over that period. The generic does better as well or better than if it wins, would have won the litigation, and consumers are left holding the bag or paying the bill. And so when we first saw these, we thought these were kind of, no-brainers. I mean, in the sense that the patent is not an absolute right to exclude. You have to prove that the patent's valid and the product is infringing. And what's going on in these settlements is that the branded companies are basically taking a share of their monopoly profits, giving them to a potential competitor to secure an agreement not to compete for a period of time. It seemed to us like this was a core antitrust violation. We were therefore surprised when appellate courts, including cases involving the FTC, came up with a very different view. So in 2003, 2005, the 11th Circuit sort of started down the road of saying that this kind of settlement could only be anti-competitive if the settlement sort of prevented competition beyond patent expiration, or the suit was a sham, or the patent was obtained by fraud. So basically, the legal rule the courts wanted to say was you should assume the patent is valid and infringed, and only if the settlement limits competition more is it illegal.
Right. The standard sort of tension between, patent and antitrust generally is, where does patent protection end and antitrust enforcement begin?
Right. What happened next, right, was that these agreements, they were exploded. So in 2004, last year before, this 11th Circuit decision, there were no pay-for-delay settlements. By 2012, there were almost 35. The Supreme Court granted cert, and in 2013, in the case called Activists, rejected the appellate court test and said, no, these agreements are subject to antitrust review. We don't assume the patent is valid and infringed. And by 2016, the agreements had largely disappeared. Now, in the course of that decade, that the government was trying to convince courts that, look, eliminating potential competition can be an antitrust violation. These deals cost consumers, I did an analysis, over $60 billion in prescription drug costs. And that that was a huge, huge cost. Post-Activists, the pay-for-delay settlements have disappeared, right? But all the parade of terribles that the pharma industry was saying would occur, if you don't have pay-for-delay settlements, nobody will settle. Not true. Record number of settlements post-Activists. If you don't have these if generics are going to get paid, can't get paid, they're not even going to try to challenge the patents. Also not true. Patent challenges are way up.
And so
branded companies.
So what do the settlements look like today? Do we still see pay for delay or not pay for delay?
So what we see, according to the FTC, that's a great question, by the way. Sorry, and I didn't mean to cut you off. I just get excited. What we see every year, the FTC produces reports on the settlements because back in 2003. Congress was so concerned about this, they passed a special law that said all these settlements have to be filed with the FTC. And what we see is that what the FTC reports is there an agreement to delay entry? And is there some form of compensation within the agreement? And so when they say something as a potential pay-for-delay settlement, it has both of those qualities. And it might be that it's a cash payment. It might be that the brand is agreeing not to compete with the generic post-generic entry, what's called a no authorized generic, or there might be a sort of a deal that's part of the settlement, like the brand buys a product from the generic. So they cast this wide net. And what they're saying by 2016, there was only one of those. So most of the settlements, maybe they agree on a date, but with no cash changing hands. Or no sort of value changing hands, so that the generic's not getting extra consideration for agreeing to delay. Or sometimes, the generic's already on the market and so there's potential damages, and the generic agree, they're compromising on damages. So those are the kind of settlements they're seeing. There could still be anti-competitive. They could still be anti-competitive, but without further, I'm not. You would have to know a lot more, and they're not the facial pay-for-delay settlements, which were so blatantly anti-competitive.
So, Mike. So this is my question. So, how long did it take us to get there? How many years?
Yeah. So it took from. So let's start with the FTC action. So we won't count how long, that we at the FTC were, so everyone thinks we, because I was there, then are too slow. 2001 is when the FTC filed the shearing case. 2015, I believe, it was the activist decision. And so and basically the sort of lenient rule, what's called the scope of the patent test, which was the bad test, that was basically lasted for over a decade. And this isn't the hard question. There are harder questions in pharma. This one shouldn't have been one. And although things look good today, there's the FTC has a case sitting in front of the Fifth Circuit. And if the Fifth Circuit sides with the defendants, it would seriously undercut the activist rule. And one thing we need to understand from pharma is the incentives to engage in conduct that delays generic entry are massive. And so any loophole the courts give companies to be anti-competitive, it is worth their while to go forward, right? And that's what we see with how these pay-for-delays all shot up when the legal rule was lenient. and disappeared when it was more strict.
Yeah, so activists may have been 2013. I was a little bit involved in that case, but the point is made, which is, gee whiz, we fought that battle for, 15 years. And the incentives, as you say, the stakes are so high that there are huge incentives to fight very hard. Well, Mike, what does that tell you about what's coming next?
Right. So what's coming next, or I guess what we could say is what's the here and now is the FTC has a case involving Daraprim, which was a very hot topic in the press back a couple of years ago. I'm not going to guess on the date because I'm probably going to be wrong, and John will correct me again. But Daraprim was this product that there was this pharma executive, Martin Shkreli. They purchased the product. They then raised the price of Daraprim from $17.50 to roughly $750. The product is an important antibacterial product, I believe. But they went farther. They intentionally tried to prevent that. They engaged in a number of strategies to basically prevent generic entry. So the first thing they did was they signed agreements with all their distributors that prohibited the distributors from selling any product to a generic company. Now, the reason you do this is for a generic to get approval, they have to run tests that show their product is the same as the brand product. So they have to have the branded product to run the test. So if they can't get 1,000 or 1,500 samples of the brand, they can't file their application to get generic approval. They can't sell the product. But they didn't even stop there. They then went to the companies that manufacture the active ingredient, which is the thing that makes the drug work, right? And they signed agreements so that those companies wouldn't supply anybody else. So you couldn't even get the active ingredient, and if you could get the so you couldn't make your generic version, but even if you could go out and get a new active ingredient supplier, you weren't going to get the branded product, so you couldn't get approval. And the third thing they did was they also signed agreements with their suppliers that they would not report their sales data to the company that collects pharma data. So like their competitors couldn't figure out like how big the market was and how much money was being made. So they did all this. Go ahead. Sorry.
So in the Daraprim case, you mentioned a few pieces of conduct that the party engaged in. Is the FTC alleging that each action in and of itself is a violation of the antitrust laws, or holistically all conduct, collectively is a violation of the antitrust laws?
So like any good litigators, the FTC did both. They have a count that sort of incorporates everything, and then they have separate counts on the monopoly maintenance, and then they have a count talking about the restraint of the API supplier manufacturer's exclusivity, and the limitation on the distributors selling to other companies.
And what's the status of the case? When do we expect a verdict?
Well, so they filed it this year. I don't know. The most interesting thing, based off of the docket just yesterday, they're having a discovery dispute. People may know Martin Shkreli actually is in jail for insider trading. And apparently the allegations in the complaint is he, like a mob boss, continued to sort of run this scheme from prison, perhaps not like a mob boss. He did it over the general prison phones, which are all recorded. So the FTC got those recordings. And so his attorneys are saying it's protected by attorney-client privilege, and the FTC is saying, no, it's not, because there are ways to talk to your lawyer without being taped. Prisons allow that, and he did not avail himself of that. So maybe he needs to spend a little more time with, whoever the John Kades are that are currently in the same prison with him. But it's just sort of wild that this is occurring. Not, this isn't some numbers racket. This is, in the heart of the U.S. Pharmaceutical economy.
Well, interesting character, no doubt, and it will be interesting to see what happens in the coming weeks and months. You mentioned also a disgorgement issue that's also live and well before the Supreme Court. Right.
So, one of the things is sort of obvious, right? Whether we think about pay for delay, where, for example, where a branded company in the Cephalon case paid somewhere between $100 to $200 million for generic companies, but protected close to over $4 billion of revenue, it's a really profitable strategy if it's legal, right? And so what that means for enforcement, the problem is these companies don't settle if the only thing that's going to happen to them is they're going to be told not to do it again. And so in this area, the FTC has been very aggressive in pursuing what's called disgorgement, where it says not only did you violate the law, but we are going to take back the illegal profits you earned. And that is since that authority arose out of a statute given to the FTC in the mid-1970s, and for over 40 years, universally, courts had interpreted the statute broadly to allow for disgorgement. That has suddenly changed, most notably in the Seventh Circuit. It overturned its own precedent and said the statute did a sort of plain language read and said, no, the FTC doesn't have disgorgement authority. Meanwhile, the Ninth Circuit just issued a decision where they sided with the majority of courts. That case just was accepted before the Supreme Court. So if the Seventh Circuit is correct, the ability of the FTC to bring cases and pursue cases is highly limited by the fact that whenever they bring a case, the companies are never going to settle because there's not that big of a loss, and they might as well continue to do the practice, earn the extra profits until they're told not to. So this is, a huge the result of this case could significantly inhibit the government's ability to stop anti-competitive activity in this industry. And it's not like, as we talked about pay for delay, it's not like the government has been able to quickly resolve solve anti-competitive problems initially. So we're not starting from a great place, and we could get to a much worse one.
Yeah, Mike, and we talked about before, the stakes, why are people fighting for 15 years? The stakes are super high. And I think what I hear you saying is, if you have this stick, right, for lack of a better word, that will, convince companies to be a little bit more compliant, if that stick goes away, again, remember the stakes are really high. It seems like people might be a little bit more aggressive.
Yeah. Right. And, so here, there's an interesting anecdote here. After activists, the FTC has two pay-for-delay cases. Cephalon, where they are seeking disgorgement. Activists, where they, for strategically reasons, told the court they weren't seeking disgorgement. Cephalon settled relatively quickly. Activists, they had to go all the way up to with over $1 billion in disgorgement. Activists, the defendants waited basically almost till trial and then, signed a consent saying they wouldn't do these sort of deals again. Right. So we already know what the world looks like with and without disgorgement.
Fascinating stuff. Mike, what's the next issue on your radar? What else? What do you think is the next big thing?
So, I think this is going to follow where the drug pricing debate is, and what we've seen in the last couple of years. There's concerns about the price of what are known as biologics. So, right, when we think of the traditional pill pharma products, it's that pill that's sort of manufactured. It's sort of chemical. Biologics are drugs that are made from living organisms. The most well known is probably insulin, Humira. Right, and these are very expensive to manufacture. They tend to have smaller target populations, not always, but they also tend to be extraordinarily expensive. So even as of 2016, biologics accounted for $1 out of every $4 in prescription drug spending. And Congress back in 2010 passed a bill that was supposed to try to create a allow for generic versions of biologics. And if you wanted to see the development of what are generic biologics, they call them follow-on, it has not been greatly successful, especially compared to Europe. So Europe has many more generic follow-on biologics on the market than the United States, and that was by design. Our process was much more deferential to the innovators. But what's also interesting is that even when biologics get on the market in the United States, they have a far more limited impact. So,
sorry, and when you let me just interrupt you. So there's the biologics, and then the we shouldn't, I guess, call them exactly generics because, as you mentioned, they're sort of live active ingredients, so there's no exact generic, but those are what we call biosimilars. Is that right?
Biosimilars are follow-on, yeah. Right. So, for example,
and I didn't mean to interrupt. So you had mentioned that it's more in Europe, less in the U.S. Driven, do you think, by regulation, by statute, by the design of the law, or because the FDA is more strict in regulating and approving biosimilars? What's driving that? How can we improve that in the U.S.?
So I think that's going to be an issue. So part of that, and a lot of it may be regulatory. Our law is much stricter on on the biosimilars, and the FDA has been very cautious. There's some bizarre things I won't go into that are regulatory related to how the, CMS does reimbursement that make it more difficult for follow-ons in the United States to be successful. But there's also an antitrust issue lurking, which there's a case that, interesting enough, it's Pfizer as typically a brand company is a biosimilar on a product called Remicade, right? And what they're claiming is branded companies are using rebates to PBMs as a way to create what's called a rebate trap or a rebate wall that prevents the biosimilars from getting access to getting on the prescription formularies and being covered by insurance. And that is also contributing why biosimilars are not having the same impact here as they are, say, in Europe, where they're entirely different, where the reimbursement system is entirely different. So, I just think because biosimilars are so expensive, prescription drugs are so important that at some point, I just think that the antitrust enforcers are going to look pretty seriously about whether part of the problem or part of the reason for the lack of competition in this country goes beyond sort of regulatory issues or legal issues of how the law is written, but actually making sure that there's not anti-competitive conduct that is exacerbating the problem.
Mike, fascinating stuff. What's your? I think you had one more big next thing. What's that? What else is coming?
So, I think the other big thing to talk about is, and this is the strategy called product hopping, which is where a branded company sort of tweaks its product, launches a new product, and does it 6 months to 2 years, maybe before generics would be available on the original. And they try to move as much as that market to the new product. So that the original generic, once it gets approved, there's no market. And so there are some sort of classic examples. My favorite one is there's a drug where literally all the company did was took a tablet and put it inside a capsule. But by doing that, you couldn't have generic substitution. So it protected the franchise, and I mean, on the other side, branded companies will say a lot of times these changes are important because maybe they reduce, maybe they take a drug that you have to take 4 times a day and it goes down to 1, and that improves compliance. But that issue has been very live. And so there's a real questions about how antitrust law is going to deal with that. The FTC has filed a number of amicus briefs and one settlement on the area. But also, there's a lot of push on the Hill to just legislate a solution. And, that recently happened with the CREATES Act, which had to do with a different sort of strategy that delayed generic entry. So, you never want to say legislation is likely, but I think you're going to see push maybe even before the end of the year to pass legislation. I mean, it's hard to think anything gets done in this Congress at this point, but you never know.
So, Mike, last question before we shift gears. Look into your crystal ball. Where do you see, do you think we'll still be talking about pharmaceutical antitrust issues, say, in 5 years, in 10 years?
Yes. And I think we will continue to talk about them unless the market changes such that no longer is there, that the competition looks different than it has, right? So the issue here is you have this competitive event that has a huge impact, and it's kind of a unique event, right? It's right. You can have 8 or 10 branded products in the space, and it doesn't really have a lot of price impact. But one generic has a huge impact. So you have a huge impact and a relatively. You don't have to do a lot to stop it. You basically are stopping one. Oftentimes, if you can just stop the first generic, nobody else is getting on. Or the strategies, even where you have multiple generics, are fairly costless. So this isn't like, I'm not saying that the pharmaceutical executives, that they're evil or they're bad intention. They're going to profit maximize, and they're going to, whatever, as long as something's legal, they're likely to do that. So I think we should expect that there's going to be a lot of activity wherever we set the line of what's legal and not. I would expect we're going to see activity right around that line in this industry going forward. And that's just sort of the nature of the incentives.
Bottom line is, watch this space. We'll, Mike, we'll be in touch, and absolutely we'll want to keep you thinking about it, because I agree with you. I think this is going to be an interesting issue, as far as we can see on the horizon. Let's shift gears slightly, and let me ask you an unrelated question, Mike. Tell us something interesting about yourself that we wouldn't know if we only knew you professionally.
Okay, so the most interesting thing that about myself is, through some bizarre set of circumstances, I actually have made a minor contribution into the world of art history. A friend of mine is an art history PhD, and he was doing it. He did his dissertation on a modern artist, Roy Lichtenstein, who is the guy who does the paintings that all look like comic book paintings. And in particular, the first one he did this way is a book called Look Mickey, and it's in the National Gallery of Art. And one day he says to me, nobody knows what the source image was, like where the original image he took and copied. And Lichtenstein at one point was asked later in his life, and he kind of said, "Oh, I think it came from Bazooka Gum," which would not be true. And I was just sort of perplexed, because I'm a geek and I was collected comic books. I'm like, this shouldn't be that hard to find. There's a whole industry of used comic book collectors, right? So I started trying to find it. And I sent this out, and he had gotten a lead from some guy who claimed to know but wouldn't say where it came from. So I started sending out, just emails to big comic book distributors and seeing if they recognized it. And one of them came back and said, "This isn't a comic book image that you're sending us. This supposed original. It's hand painted. It's from a book." And so you need to be looking at dealers who deal with Disney storybooks. So the first response I got was a guy in England who said, "Oh, well, we have thousands of these books. I'm sure it's there. If you come over, we'll let you look for it." Oddly, and I jokingly said to my friend, "Do you think the Lichtenstein Foundation would pay for this?" And he was like, "Oh, yeah, they'll pay for you to go do that." Unfortunately, the second one came back, and it was clear they had a book that looked like it was exactly the right book. It's called Donald Duck Lost and Found. And on page 2 is the image that Lichtenstein used. What's a little fascinating was the Lichtenstein image, right, is a cartoon image. The original is like an illustration in a book. So what he did is he took something that was, sort of more higher art and dumbed it down and made it look like a comic book. So my name actually even appears in an exhibit, one of the books where they describe an exhibit on Lichtenstein as the person who sort of tracked this down. So that's kind of the most interesting thing.
So when you started the story, Mark, when you started the story, I thought we were going to begin in the Sistine Chapel. And we end up, I'm not saying it's not impressive, just we end up with Donald Duck. And I just think that's great. That's probably more appropriate for the listeners of our Curious Amalgam.
We will certainly post, copyright provided, a picture of that image. That's wonderful.
Oh, thank you.
Do you have a letter that you got from them, that recognizes that you were the one that figured this out?
So, I'm cited in my friend's dissertation cites me, and also but I got something I think a little better than a letter. Lichtenstein's widow gave me a artist print of one of his later pictures called Mirrors. So we have like a Roy Lichtenstein print. So that's pretty cool.
Okay, we won't alert the art thieves to your address.
Thank you.
Let's go to our final section, our final segment on our program that we call the Curious Hat.
And now it's time for the Curious Hat.
As our listeners are well aware by this point, when we are together, we have an actual hat that has actual questions, and we ask the guest to pull the question out of the hat, and we ask that question. Unfortunately, since we are not all together in the same place now, I am wearing a hat, and what I have in my hand is an actual list of the questions that are numbered from 1 to 25, and I will ask Mike Kades to choose a number between 1 and 25, and I will ask him that question.
2.
Question number 2. What is your favorite movie?
My favorite movie is Henry V, the Bronick version from the late 80s.
And again, I thought we might be going with Donald Duck, and we went to the Sistine Chapel. Why is that your favorite movie?
So until I saw that movie, I hated Shakespeare. When I read Shakespeare, I'm not musically talented at all, and I couldn't pick up the verse. And I sort of felt like whenever I would see Shakespeare, it was just sort of pompous actors acting like every line was the most important line ever written in the English language. And so I go to see this, it was a date, it was first date, the woman I had a crush on, that's what she wanted to do. So of course I told her none of this. And so we went and saw this movie, and I think I didn't even at the time realize I thought it was a Henry VIII thing. So I was told, shows you what a Luddite what a Philistine I am. And so I was just transfixed by this movie, because I could understand what was going on, and I picked up the verse, and I just felt like it was iambic pentameter as dialogue. And so from then on, I sort of just became this huge Shakespeare fan, and took a class on it. And whenever I read Shakespeare, I sort of think about that movie or scenes so that I can think about how the text sounds in a conversational way. So it really had changed sort of my view of the world. So,
have you ever done any of your legal writing in iambic pentameter?
No, I'm lucky if my legal writing's in complete sentences.
Yeah, me too. I struggle with punctuation. Okay, what's the worst movie you've ever seen?
So I don't know if it's the worst movie, but the worst movie experience. My wife and I, it was our second date, and she said, "Oh, I got this great movie I want to see, Enchanted April." And so my rule was when the woman you're interested in wants to go see a movie, you say yes, because what had happened.
Yeah, it's a good rule.
And she then said, "Yeah, and you should invite all your, your friends." This was at the beginning of the second year of law school. Everybody just got back to town, so I convinced my 3 or 4 roommates. Yeah, we're all going to go to this movie. This is going to be great. Lots of fun. So we go see this movie called Enchanted April, which it's just not the kind of movie single guys in their mid to late 20s would find enjoyable. And so I was berated for the rest of law school for being the guy who advocated we see Enchanted April.
Mike, another time I'll tell you the story about the first date that I had with my wife, which ended up being at a New Jersey Nets basketball game. I couldn't even pull together the Knicks. But with that, I think we're probably at the end. Thank you everybody for listening, and we will see you next time on Our Curious Amalgam.
Thank you for listening to this week's episode of Our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.